Get ready for the dictation. Start. In other words, the submission was that the arbitral tribunal misconducted in awarding interest to respondent number 1 on their various claims when the clause 13(3) of GCC did not allow them to claim any interest on the sums payable under the contract except on government securities if deposited with the appellant. It was therefore her submission that the award to this extent was not legally sustainable, and therefore it was liable to be set aside under Section 34 of the Act. Learned Counsel elaborated this submission by placing reliance on the provisions of the Act and some decided cases cited at the bar. In reply, Learned Counsel for respondent number 1 supported the impugned judgment and contended that the aforementioned point urged by the appellant was neither raised nor urged before the arbitral tribunal nor the High Court, that is single judge, and also division bench, and hence it cannot be permitted to be raised for the first time in an appeal under Article 136 of the Constitution for want of any factual foundation and finding by any court on such plea. Having heard learned counsel for the parties and on perusal of the record of the case, we are inclined to accept the argument of learned counsel for respondent number 1, as in our view it has a force and hence deserves acceptance. It is not in dispute that the appellant did not raise the plea based on clause 13(3) of the GCC against respondent number 1 at any stage of the proceedings, either in their reply filed before the arbitral tribunal or and in submissions except raising it for the first time before this court in this appeal. On the other hand, we find that in section 11(5) proceedings, the appellant did not raise this objection in their reply and instead gave their express consent to refer the issue of award of interest payable of various claims to arbitral tribunal, considering the said claim to be arbitrable under the contract. In our opinion, the appellant could have registered their objection before the single judge at the time of making a reference to the arbitral tribunal by pointing out clause 13(3) of GCC, or could have reserved their right to raise such objection before the arbitral tribunal. It was, however, not done. Not only that, we further find that the appellant in their reply filed before the arbitral tribunal also did not raise this plea and allowed the arbitral tribunal to adjudicate the said issue on merits. If the appellant was so keen to place reliance on clause 13(3) of GCC to defeat the claim of respondent number 1 relating to the award of interest on various claims, then it was necessary for the appellant to have raised such plea specifically in their reply before the arbitral tribunal. No such plea was raised even before the arbitral tribunal, though we find that the appellant raised this ground for the first time in section 34 proceedings before the single judge, but again this ground was not pressed at the time of arguments. It is clear from the perusal of the single judge's order not only that the appellant again did not raise this plea before the division bench. In the light of aforementioned factual scenario emerging from the record of the case, we cannot grant any indulgence to the appellant to raise such plea for the first time here. In our view, it is a clear case of waiver or and abandonment of a plea and the initial at the initial stage itself. Stop.